Hello, I am Tony Vernetti, the president and founder of FEDS, Federal Employee Defense Services. Want to thank everybody for taking time away from the basketball and attending today's webinar on liability insurance for federal attorneys. Before we get started, just a little information about myself. I'm a former federal employee myself, federal attorney. Worked at a federal law enforcement agency many years. And then I worked at my old law firm, Shaw, Bransford, and Roth, defending federal officials at a variety of different agencies for a variety of years as well. These seminars typically take about an hour and a half, but we realize that you don't really have that kind of time to give up in your day, so we created this abbreviated version for you and for you to share with your friends, coworkers, and colleagues. So I have a lot of information to get through in 15 or so minutes. So I'm going to ask you to please hold your questions until the end, and then I promise I will stay on as long as necessary to answer any and all questions. So I'm going to take you back to law school here. Liability exposure for all federal employees really began back in 1971 with the Supreme Court decision called Bivens. Bivens versus 6 narcotic agents, which is a precursor to the DEA, as most of you know. And this case is basically the first case that allowed employees to be sued personally, and basically this case and cases to follow created a new cause of action against federal employees in their individual capacity. Federal officials of all kinds could now be held liable in the course of performing their duties for what lawyers call constitutional torts. Typically we see First Amendment claims, violation of free speech, free exercise clauses, Fourth Amendment, unreasonable searches, Fifth Amendment due process claims, and then, of course, Eighth Amendment cruel and unusual punishment claims against prison officers and other such officials. I'm starting with this slide because it's important that you understand the concept of federal employee professional liability insurance was created in response to this ruling, and also in response to this ruling, Congress passed legislation requiring agencies to reimburse federal managers, supervisors, and law enforcement officers up to 1/2 of the cost of the annual premium for the professional liability insurance. And most federal attorneys, and certainly all managers and supervisors, are indeed eligible for this reimbursement, 1/2 of the cost of the insurance. You should check with your agency to be sure if you're eligible for the reimbursement. I can tell you that all DOJ, Department of Justice attorneys, are in fact eligible. It's important to emphasize here that this legislation requiring agencies to share the burden of the cost really demonstrates Congress's official support for liability insurance and their understanding that there are risks associated with your federal employment that cannot be completely cured with legislation. So the policy was originally designed only to cover civil exposure for federal employees. Fortunately for you, it was later expanded to cover attorney fees for investigations, disciplinary actions, and criminal cases. So essentially there are 3 areas of liability exposure for federal employees that we are going to talk about today: civil, administrative, or miscellaneous cases, investigations, and finally criminal. So first, with civil, we are talking about those personal capacity lawsuits that I just talked about, the Bivens action claims, constitutional torts. And generally speaking, the good news for you as federal attorneys, you by and large have absolute immunity for any lawsuits arising out of the performance of your professional legal duties. Historically, this was called prosecutorial immunity, but DOJ doesn't like that word because they want it to essentially be able to apply to all federal attorneys, and they contend that this absolute immunity doctrine does apply to all federal attorneys who are working in furtherance of the judicial process and or rendering a professional legal service. So basically some fancy words there to say you really do not have anything to worry about with civil lawsuits when you are performing a legal service for the federal government. Other federal officials, such as law enforcement officers, only enjoy what's called qualified immunity for these personal capacity lawsuits. And those of you attorneys who perform non-attorney functions such as managerial functions or other services that are not legal in nature, you could also be vulnerable and be only entitled to qualified immunity. So I want to briefly just cover some of these concepts of the civil lawsuits, even though you are immune, because also, as you know, as attorneys in the federal government, folks always come to you, ask questions, and if you're being asked questions about civil liability for other federal officials, I want to make sure that you have these basic concepts down. So first, if you get sued, representation. Who's going to defend you? DOJ representation is not mandatory, and it certainly is not automatic. It is the sole discretion of DOJ as to whether they represent you. It's a two-part test. Scope of employment, which is usually answered yes, and then is it in the interest of the United States to represent you? So even if it's clear that you're acting fully within the scope of your employment, DOJ must also determine that it is in the interest of the United States to provide you with that defense counsel. So if you're being investigated for some sort of wrongdoing for the very same reason that you're being sued, then you can see how DOJ can't and won't be on both sides of that. So you would be left to yourself to hire your own legal counsel, unless, of course, you had the Fed's liability insurance, which would provide representation for you in that circumstance. The next concept is immunity. You don't have absolute immunity for personal capacity lawsuits like you do for lawsuits under the Federal Tort Claims Act. That's what we're talking about. The third concept is indemnification. So even if DOJ provides representation, they determine that it is in the interest of the United States to represent you, what you need to take away is that it is still a lawsuit against you personally. So you could still be liable for a judgment if one is entered against you and the agency will not indemnify you. And this is where another part of the Fed's policy comes in. It provides that indemnity protection of $1 million or $2 million, depending upon which policy you purchase. So again, most of you federal employees, you have absolute immunity. You don't really need to worry. Other federal officials, and when you're doing work outside of your legal responsibilities, you may only have qualified immunity for these personal capacity lawsuits. And just to recap, the insurance protects you in these three ways. It provides the legal defense if DOJ declines to represent you, and it pays damages. We talked about that. This other third part of it, coverage counsel, we didn't talk about. What that means is if DOJ is on the fence as to whether they would rep you or not, we may hire coverage counsel to hopefully convince DOJ that they should be representing you, and or in particular cases, even when DOJ is in defending, we may want to hire coverage counsel to advise you of your rights and circumstances involving your case, someone else that you can turn to get advice. Before we leave civil, I just want to mention that DOJ representation, denial of DOJ representations for all federal officials is pretty rare, okay? And with actual liability being even rarer, probably less than 5% of the cases. But it does happen, and for how inexpensive the insurance is, I don't know why you would want to risk it, be one of the ones that slips through the cracks. Here's the real bang for your buck as a federal attorney for the liability insurance. This is the main reason that federal attorneys protect themselves with liability insurance, and this is also the reason that associations such as NASA, the National Association of Assistant United States Attorneys, and other professional attorney associations recommend liability insurance for federal attorneys of all kinds. So whether you are a DOJ attorney, an attorney in a regulatory agency doing regulatory work, or an agency attorney making decision on policy matters, a supervisory attorney, or if you're just making decisions that affect the public or other federal employees, you need to understand that while you enjoy what we just talked about before, absolute immunity for civil lawsuits, you are not immune from allegations or charges of professional misconduct, and they usually result in one of these investigations or administrative matters. The most common allegations of wrongdoing against federal attorneys, could allege abuse of investigative authority, prosecutorial authority, abuse of position. For litigators, we have discovery or other Brady violations, misrepresentations to a court or other tribunals, failure to disclose conflicts of interest, failure to follow supervisory instructions or standard SOPs, general negligence of performance of duties, ethical allegations, any real professional misconduct, alleged to provide false and inaccurate information or suborning, perjury, in court. These are all cases where we've seen these types of administrative investigations initiated against federal attorneys. For AUSAs, Assistant United States Attorneys, most of the allegations of professional misconduct are really made and driven by opposing counsel, defense counsel, defendants, civil litigants, or even judges and magistrates who are looking to make a political point, throwing a case out or overturning, a verdict. All those things, as you know, can and will result in an OPR investigation, which I'll talk about here in a little bit. For regulatory and other agency attorneys, it is that public and congressional scrutiny that you need to be concerned with. In the last few years, many federal attorneys have seen how this scrutiny can lead to internal investigations and congressional inquiries. Just ask, in the post-Madoff era, just ask any SEC attorney what they think their vulnerability is. In fact, I just got off the phone with one this morning who is the subject of an IG investigation involving something that has to do with their investigative responsibilities. So the Fed's liability insurance protects you in this way. It provides your own attorney up to $200,000 to defend against any of these administrative or miscellaneous matters. So it provides an attorney to cover you throughout the investigation, prepare you, defend you, all the way up to the conclusion of it. In the unfortunate event that there's a disciplinary action taken against you, the insurance provides a defense at the agency level, and if it has to be appealed outside the agency, it covers that as well. It covers judicial action proceedings. It even covers state bar investigations and proceedings that may arise out of the performance of your official duties. I want to briefly talk about OPR, Office of Professional Responsibility, OIG, and these misconduct investigations. If you're a DOJ attorney, allegations of misconduct such as alleged Brady violations, failure to disclose conflicts of interest, misrepresentation and pleadings, those allegations are really subjected to some rigorous investigation by Department of Justice's Office of Professional Responsibility. While I don't have time to go into all the particulars of a DOJ OPR investigation, I do want to mention that there is an excellent article on our website at fedsprotection.com written by one of my former law partners, Deborah Roth, really detailing the specifics of the OPR process and investigation and explaining how the insurance would help you. The main point I want to emphasize here for all attorneys, okay, is that whatever the investigated entity is, whatever kind of professional legal job that you have in the federal government, the fallout can be devastating to your career and reputation. So why wouldn't you want to get your own legal advice? Like the old saying goes, he or she who has themselves as their attorney has a fool for an attorney. I can't tell you that how many of our insureds who are very accomplished attorneys in their own right, some, clerked on the Supreme Court, they have really found the objective insight and advice from private counsel to be very beneficial at this initial stage, if for nothing else, to see past their own subjective view of the allegations and manner in responding. As I mentioned, judicial sanction proceedings are also covered, and I want to emphasize that it's more than just the litigators too that are in court, having to deal with the judges day to day. I remember back Department of Interior lawyers, Department of Treasury lawyers dealing with the infamous Indian Trust Fund case. There were discovery violations, and the whole offices were held in contempt, and certain lawyers were under investigation because of that. The same thing happened in Waco discovery. So this is another important part of the process, of the insurance, that if you're subject to one of these, you're able to obtain your own legal counsel to help you defend. This slide is specific really for lawyers who are also supervisors and managers. You could also face an Office of Special Counsel investigation, which, as you know, focuses on whistleblower reprisal or other prohibited personnel practices. You could be a responsible management official in an EEO complaint. A disgruntled employee could file a complaint against you, and the Fed's liability policy entitles you to have your own lawyer to assist and help you defend in that case, or really put forward the affidavits that you're going to be responsible for doing. And with OSC sitting down for that interview, the Fed's insurance allows you to have your own attorney present there. This is important, to emphasize, and I know all of you know this, is while the agency lawyers may be involved in these complaints, their duty of loyalty is still to the agency. Okay, while your interests may be aligned with theirs, it's still their duty of loyalty is to the agency. So there could be a situation where they are advancing an interest that's adverse to yours, and it's helpful to have your own independent legal counsel. I want to briefly mention congressional hearings, congressional oversight and investigations, because often it is the federal attorney that I like to say is served up to Congress, as a sacrificial lamb in order to shield or protect either a political official or some other senior agency official. So the liability insurance will provide your own legal counsel for this, even though the agency may be providing you attorney as well. So this is just a quick recap of what the insurance provides if you are the subject of one of these investigations or administrative matters. Essentially, it helps you defend against the allegations. It will prepare you for the agency administrative or investigative process, and I've explained how really important that is, that you get your own independent legal counsel, if for nothing else, to have somebody that's not only an expert in federal personnel law, but is just simply more objective and can provide some advice to you in that regard, because you're often too close to it, too angry about it, and really can't be objective and thinking about the best way to respond and or defend. And again, a great added benefit of the liability insurance is that any state bar proceeding that arises out of your performance of your duties is going to be covered as well. And I mentioned the DOJ OPR process. For example, if they conclude during their investigation that professional misconduct has occurred, they are required by their policy to report that to all the state bars for which you are licensed, which is why that's one of the first questions they ask you when you are the subject of one of those investigations is, where are you licensed to practice law? So finally, I just want to quickly mention your criminal exposure. As a federal attorney, you know that there is very little you can do wrong in the federal government and not have it also be a violation of Title 18, which is, as you know, is a criminal code. Some of the most common allegations we see are conflict of interest statutes, where intent is not a prerequisite, if you're involved in appropriating funds, misappropriation of funds, release of Privacy Act, or other statutorily protected information could result in a criminal investigation. Really, any allegation that involves the misuse of your position or authority. I don't need to tell you how important it is to have your own counsel if you are notified that you are the subject of a criminal investigation. It's obviously very important. So this is just a recap of what the policy covers. And I would like to mention here, I've been defending federal employees for almost 18 years now, and I really founded the Feds on a platform of education because I really wanted to, provide education to the entire federal community about this liability insurance, because I'm constantly amazed, how many people who find themselves in hot water that don't have this very affordable coverage. I can't tell you how many times I've took $50,000, $75,000, $100,000 of somebody's hard-earned money to defend them, that if they just would have had the policy, they would have been fully covered. So, even if you're ultimately vindicated, if you are the subject of one of these allegations, at $400 an hour, the costs are going to add up very, very quickly. And the cost for 1 hour of legal service, believe it or not, is more than you will spend for the insurance. So you don't have to break the piggy bank to get the liability insurance. For our $1 million base policy, it's only $270. That's $135 after the reimbursement. And we also have payroll deduction available starting at $12 a pay period. So it's very, very affordable, and there's simply no excuse, for you to not consider having this type of insurance at this very affordable price. This is my final slide, and I can't emphasize this point enough, that it's important to have the insurance in place before something happens. Just like your home or auto insurance coverage, you can't get in a car accident on Monday and buy your insurance on Wednesday to have it protect you. You need to have it in place prior to the allegation, claim, or suit. Can't tell you how many times I have people calling me after their house is on fire, and it's just unfortunate. There are 3 ways to get enrolled. It takes less than 5 minutes. Easiest way is to go on the website at fedsprotection.com, or you can send us an email. We'll send you a one-page enrollment form, which you can also download from our website, and you can also enroll by phone, particularly if you have questions. You can give us a call at 866-955-FEDS. So that concludes my presentation today, and I'll open it up for questions. And I hope that we've provided you with the necessary information so that you can make an informed decision on whether you need liability insurance or not.
Tony, can you wait just one moment? I don't see any questions at this time.
Certainly can.
Okay, I think you did a great job. We don't have any questions.
Okay, thank you.
The organizer